Hello and welcome students. Today we will understand international law and how it has been practiced in India. To understand Indian practice in terms of international law, it is necessary to understand the pre-constitutional, that is the prior to our independence. The situation was India practiced the customary international laws and treaty laws similar to the British practice. That is what British was ruling our country. And post-independence, India adopted the customary international laws similar to the British practice of incorporation with a dualistic view. So, what is British practicing till now is incorporation and with a dualistic view. We are not going to make any enactments for the sake of international law. The same has been followed in India and British. Again, this post-independence, the framers of constitution, they were inspired with the Charter of United Nations Organization. So they elaborated the provisions in the constitution in matters of adoption in its national laws. So constitution was elaborately specified the provisions of international law into national laws. And this is what the Constitution of India elaborated the provisions relating to international law and its application under the following articles. So Article 51 is very important to understand the international laws applied by national law. But it is not that important because Article 51 does not specify the exact position of international law in India, because since Article 51 is contained in Part 4 of the Constitution of India, and Part 4 is the directive principles of state policy. So it is non-justiciable, and these international rules cannot be enforceable through the courts. Any courts, maybe Supreme Court or the lower courts, any courts cannot enforce this international law. So let us understand the Article 51. Overall, Article 51 states about promoting international peace and security. The state shall endeavor to promote international peace and security. Next, maintain just and honorable relations between nations. C. Foster respect for international law and treaty obligations in the dealings of organized peoples with one another. And D. Encourages settlement of international disputes by arbitration. So overall, it says in the first clause about promoting international peace and security. In the second clause B, it says about maintaining the relationship between the nations, that is between other nations and the India. And this subsection C states, clause states about fostering respect for international law and the treaty laws. And D states about the international disputes to be settled through arbitration. Overall, what this Article 51 states? Yes, it includes both the customary law and the treaty laws. In Article 51, both these laws are being treated on the same footing. So you must not consider that it is only related with the customary laws or with the treaty laws. And specifically, Article 51 of C stresses on pacta sunt servanda, that is the principles in matters relating to treaty laws that we have mentioned under Article 51 of C, that treaty laws should be respected. And Article 51 is incorporated in Part 4 of the Directive Principles of State Policy. So it is the principles of state policy. A policy needs to be governed by the state. So it is the fundamental in governance of the country, and thus these uh, provisions under Article 51 are not enforceable in a court of law and are non-justiciable as per Article 37. That is another Article 37 state that these these provisions under the Part 4 Directive Principles of State Policy are just a policy, and these policies are not enforceable in a court of law and are non-justiciable. Any individual cannot go to court and state that this international provisions has not been applied. So no one can individually or as a whole, a group cannot go and state that this injustice has happened to him in regards to the provisions of international law. So it is not clear that how international law is applied in India. So particularly we will understand customary international laws, how it has been applied in India. So India is following the doctrine of incorporation. That is, we are not making any enactments, but whatever the common or similar laws or provisions applicable in both India and in international laws are incorporated, and Indian courts should apply customary rules of international law only if they are not overridden by clear rules of domestic law. If our domestic law is clear on that particular law or subject through legislation or through any guidelines or through any constitutional, what you can say, provisions, then we will follow it. That is, Indian laws will override the international law. And if they are in conflict with the domestic law, that is our national laws, then courts shall apply this domestic law, the national law, instead of applying the international law. In one of the case, that is the Gramophone Company of India Limited versus Birendra Bahadur Pandey case, Supreme Court held that national courts cannot say yes if Parliament has not said no to a principle of international law. So any act has to be enacted in the domestic law, then only the international laws are followed. Else, if the national law is different and international law is different, international laws are not followed. Again, customary international law. In another case, in Sri Krishna Sharma versus State of West Bengal, the Calcutta High Court has clarified what the internal laws are. The internal laws are the Constitution of India, the statute enacted by the Parliament of India, and the statute enacted by the state legislatures. Let us understand how the treaty laws are followed by India. So, under Article 253 of the Constitution, it has been specifically stated that Parliament has power to make any treaty laws for the whole or any part of the territory of India for implementing any treaty, agreement, or convention with any country or countries, or any decision made at any international conferences, association, or other body. That is what agreements we can say. The treaty laws to be a contract laws or agreement laws or promissory laws, promised laws. So the Parliament has the power to make laws on this treaty or conventions. Again, India in terms of treaty applies transformation theory. That is what India has to enact laws, separate laws as per the treaties or the agreements made in international level. They have to make enactment in the national laws, and thus it is submitted that the treaties shall not be binding upon Indian courts unless they have been implemented by the legislation. If you are not enacting any laws as per the treaty laws, then courts will give the laws which are prevailing in the national enactments enacted in our country will be overridden by the treaty laws. So it is necessary to make some transformation, that is enact the treaty laws into national laws. So there are certain exceptions, that is we are transforming, we are enacting laws for treaty laws, but there are certain exceptions. What are they? Some conventions in relation to human rights has been applied as incorporation theory, not as transformation theory. That is, we have accepted without making any enactments, that is without legislation. We have accepted the treaty laws. We haven't enacted any laws, but those laws, that is the treaties, conventions, we have attended, our foreign diplomats or foreign ministry has attended those conferences, have signed those agreements, but we haven't made any enactments. But even then, there are few provisions relating to human rights which we are already following through our constitution. That is the fundamental rights, all those are inculcated. So we haven't made particular separate enactments on that, though we have made some human rights laws or enactments. but even then some provisions we haven't enacted. So it is applied as incorporation theory. And in certain cases, that is a Vishaka case, Vishaka versus state of Rajasthan. Here the Supreme Court held that the international conventions and norms are to be read into them in the absence of enacted domestic law. That is, we didn't had any separate law for the sexual harassment in a working place. So the Indian courts, the Supreme Court has taken the principles of international law, the principles of conventions into our domestic law. They have made some guidelines in regards to sexual harassment. So, without transforming those conventional laws into our national laws, we have taken those laws of our national laws. So, these two are the exceptions. So, this was about the practice of India in terms of applying the international laws in their national laws. So, thank you.